In this clip, attorney Chelsey Hesla addresses the question you have to ask yourself every time before opening the probate case. Where should the case be filed?
Okay, next important question is where the probate should be opened. Where should we administer the will? It's not always a simple question, and this one can require a little bit of due diligence and forethought. Most jurisdictions state that jurisdiction and venue is appropriate in the jurisdiction or county where the decedent was domiciled at the time of death, or where the decedent owned real property at the time of death. Those are the two main ones that we usually see. But just because a court might have jurisdiction doesn't mean that it's going to be the most cost or time efficient option. So always helpful to determine if there are any assets in a different state that are going to require an ancillary jurisdiction. If the answer to that is yes, I highly recommend consulting with an attorney in that jurisdiction first to understand what that process looks like. Because I'm located in Arizona and we're so close to California, that's probably the state that I tend to have the most overlap with in my practice. And California has a very different way of doing their probate administration relative to Arizona, at least. The way their fee structures for attorneys work are different. Everything is different. And so sometimes even though arguably in a given situation, it might, at first blush, seem as though Arizona is the appropriate jurisdiction, sometimes because California does things so differently than Arizona, or Arizona is so different than California, if you will, it makes sense to do it in one place over the other. And those conversations up front can really help save the clients a lot of money. So highly recommend evaluating whether particularly if there's real property, but honestly, even with personal property, this comes up a lot. I'm dealing with a case right now where there's a bank in California that is refusing to give us money, even though that's personal property. Subject to our Arizona probate, they are requiring a California probate. And given the circumstances, it still made sense for us to open up the initial probate in Arizona, but under different facts and circumstances, it might have been a big waste of money. So just something to keep in mind. And then obviously, when I refer to foreign assets, that applies to not just in different states, but different countries as well. That's obviously also going to require some expertise and can be quite a bit more complicated.